I hope you've all had a chance to watch my last video on the First Amendment tests. I gave that to you because you can always tell the analysis they're using from the test, and you could tell the test they're using from the analysis. And we are going to look at Turner v. Driver. There's an ongoing discussion in Bunny Boots BBI chat over what we won with Turner v. Driver. I believe what Mr. Turner won is probably legal fees. I don't know how much or how little his lawyer carried them on it. I hope his lawyer did that pro bono, or at least in part pro bono. But what we won with Turner v. Driver is police officers in the Fifth Circuit can no longer claim qualified immunity if they violate someone's First Amendment right to film in a traditional public forum. That's what we want. So the next guy who gets treated like Mr. Turner, who gets arrested and stuck in the back of a police car for hours or an hour in the heat with no AC, cuffed up for no reasonable suspicion and no probable cause, just for filming from a sidewalk, that person will be able to sue the pants off those police officers and hopefully will win. But let's look at the important thing. So this is where I'm on page 13, as you can see. This is where the court is explaining, we agree with every circuit, and we each has concluded the First Amendment protects the right to record the police. And then this is, as the First Circuit explained. So this is what they're adopting. This is their analysis that they're adopting. They're adopting the First Circuit's analysis. The filming of government officials engaged in their duties in a public place, including police officers performing their responsibilities, fits comfortably within basic First Amendment principles. This right, however, is not without limitations. Like all speech, filming the police may be subject to reasonable time, place, and manner restrictions. If you just finished watching that video, that should be cluing you in. In this case, however, we need not decide which specific time, place, and manner restrictions would be reasonable. Nonetheless, we note that when police departments or officers adopt time, place, and manner restrictions, those restrictions must be narrowly tailored to serve a significant governmental interest. That should also be setting off little alarm bells. It should be cluing you into what test we're using. That said, to be constitutionally permissible, a time, place, and manner restriction need not be the least restrictive or least intrusive means of serving the government's interest. And there is 53. Actually, yeah, 53 is McCullen, but the important one was 52. Which is also McCullen, this one right here, talking about the narrowly tailored to serve a significant government interest. So, McCullen v. Coakley, that's what they're quoting this from. This is McCullen v. Coakley. The second paragraph is the language that they're quoting, but we're going to start off in the first paragraph that I've highlighted here. McCullen v. Coakley. Consistent with the traditionally open character of public streets and sidewalks, we have held that the government's ability to restrict speech in such locations is very limited. Grace, Supra at 177. Grace is US v. Grace. In particular, the guiding First Amendment principle is that the government has no power to restrict expression because of its message, its ideas, its subject matter, or its content. Applies with full force in a traditional public forum. And then they're quoting Police Department of Chicago v. Mosley. As a general rule, in such a forum, in such a traditional public forum, the government may not selectively shield the public from some kinds of speech on the grounds they are more offensive than others. We have, however, afforded the government some wider leeway to regulate features of speech unregulated or unrelated to its content. Even in a public forum, this is a traditional public forum, you can tell it because of the preceding paragraph, the government may impose reasonable restrictions on the time, place, or manner of protected speech, provided the restrictions are justified without reference to the content of the regulated speech, that they are narrowly tailored to serve a significant government interest, and that they leave open ample alternative channels for communication of the information. And they're quoting Ward Rock v. Racism. So we know that it is a traditional forum analysis. Because it is a traditional forum analysis, that means they are talking specifically about filming the police in a traditional public forum. The only way the police can restrict your right to film them in a traditional public forum is if they have time, place, or manner restrictions. I don't, again, as I said in the previous video, I don't see how exactly they could get a time, place, or manner restriction that would be reasonable. So I don't foresee any time that you could be restricted from filming the police, just kind of carte blanche, if you're in a traditional public forum. So I hope that helps. I hope that brings a little bit of understanding to Turner v. Driver. Thank you very much for watching, and have a great day.